welcome back to the morning show here on Arise News. Well, it's that time on the program when we usher in our first guest, Sonnie Ekwowusi, a lawyer and chairman, Human and Constitutional Rights Committee of African Bar Association. Good morning. Good to see you, sir.
Good morning. I'm happy to be on Arise again.
Thanks for joining us.
I've become here in the past, so I'm happy to be here again.
All right, good.
Good to have you.
Yes, thanks.
Okay, so let's talk about one of the biggest issues that Nigerians are still battling with, the verdict of the PEPC, the Presidential Election Petitions Court, the 6/9. Somebody like you, will call it. I know that there are still mixed reactions. Yeah. Opinions are divided. Yeah. But where do you stand? And why? What will inform your position? Will it be what some opposition members have called the difference between justice and judgment?
Very good. In fact, that's where, I mean, asking where I stand very much on the side of justice. Because, the essence of legal system is dispensation of justice. And when justice is taken away from society, according to St. Augustine, all that remains are empty robberies, are robberies and all that. And that the Tribunal government have been trying to win investors to invest in Nigeria and all that. We all support him on that. But investors will not come to invest in Nigeria if there is no rule of law, if there is no justice. You and I know that. You don't even have to be a lawyer to know that. But when we talk about justice, justice is something that is central to every human being and to human society. Giving each person what that person deserves. That's what, in simple terms, is the meaning of justice. So what people are saying, because we are commenting about this judgment now, about this verdict, because it's already in public domain, so it's no longer a secret thing. And the members of the international community are also commenting on that. And everybody is quarreling with the judgment because of absence of justice. Justice, as was illustrated by late Chukwudi Oputa, the late justice of the Supreme Court, was very cerebral and very, he was called the Socrates of the Supreme Court at that time. And he said in the case of Josiah and they said that justice is not a one-traffic thing. It's not a one-traffic rule. It's not even a two-traffic thing. Justice, according to him, is a two-traffic lens, if you like, because you have to do justice to the parties in the suit. In this case, Obi, or less President Tinubu, Obi, and Atiku, and also justice for the society. Okay? When a court is making a ruling, or when a judge is giving out a judgment, he has to be worried about giving justice to society because, death is something that affects everyone. Tinubu, Obi, and Atiku, they will come and go, but the society remains. But when some certain justice have been thwarted in the society, there is a big problem. And that's why people are quarreling with that verdict, because in as much as it tries to do justice to Tinubu, Obi, and Atiku, it failed to do justice to the society. That judgment goes against public policy. It goes against judicial norms and judicial attitudes. It goes against what is reasonable, justifiable in a democratic society. In the sense that you have a verdict that obviously did everything possible in an attempt to give judgment to one person, then thwarted all that we know about, about trial, about elections, about all that we know about the Constitution. For instance, the sections of the Electoral Act that has to do with uploading of the elections through Beavers and through INEC. This was a regulation that was made, Regulation 38, that was made by INEC itself, the electoral body. Now, after the presidential election, INEC intentionally went against its own rules, not even the party now, INEC. And don't forget that INEC is a party to this, to the verdict that we are discussing. And then the court did not say anything about INEC, that went against their own rule. Regulation 38, which specifically stated that
No, but the court did say something.
Yes.
They said that INEC had the right, to carry out
yes,
its own rules.
INEC has the right, but I'm saying that okay, INEC said something, but that's really quite unjustified because you can't have...
No, but Mr. Ekwowusi,
what
I'm saying, sir,
it's a mandatory provision.
You may disagree with the position of the court, but are you saying that it is not justice?
Yeah, of course.
Except somebody else's
No, it's not bad because, let me just first say that I'm not a member of the Labour Party, I'm not here for Dio or Chico or Tinubu or whatever. I'm not in any of this political party. What I'm trying to say is that the way people perceive it, that this is a mandatory position. In fact, that provision said they shall upload. And then INEC now went its own rule, and the court now said INEC can upload results through any means. And we are saying no. But the law is there, the Electoral Act is there. Okay, let's leave that for now. Without going to the issue of the 25% of Abuja, as have been controversial and all that. Before coming here, my friend was telling me, he was asking, do you think that it is right, or morally justified for somebody to score all 25% in all the states, because that person did not score 25% in Abuja, and then you are saying that the person must score 25% because, okay. I said, look, what is happening is that the court said that Abuja is just like any other state, fine. But considering the judgments of our courts, the Supreme Court, in 2003, in the case between Obasanjo and Buhari, okay, the court specifically said that Obasanjo had to score 25% in Abuja if he has to be declared winner of that election. Then 2008, in the case between Buhari and Yar'Adua, the same Supreme Court stated that, look, that 25% has to be scored in Abuja. Anyway, so we are looking at the consistency of the judiciary, of the pronouncements of our judiciary in Abuja, okay? Can the court also be consistent in saying that, look, Abuja has a special status, okay? And if you say that a candidate doesn't have to score 25% in Abuja, well, you are saying something different from what the Supreme Court has said in the past. Right now, you know that the Abuja citizens are going to court and asking for, okay, if you say Abuja is not, it doesn't have a special status, okay, Abuja is just like any other state. Okay, give us our governor, give us our senators and all that. Now, this is what you get when there are inconsistencies in pronouncement, All
right.
What I'm saying, in effect, is that look, we have to stand by justice, okay? Our courts should be consistent in their pronouncement. We should guard against anything that towards substantial justice. We should, retain, these judicial norms and judicial precedent, because once they are destroyed, the whole society is destroyed.
All right, so the Petition Tribunal ruled that Abuja is not a special state and should not be treated as a special state. But you wrote a piece, and which is what you have highlighted. You highlighted the Beavers and the 25%.
You have read it.
I read your speech, and you said that the Supreme Court, in which you said that the Petitions Court verdict is antithetical to judicial norms and values and a big threat to the independence of the judiciary. And for people that have not read your piece, I'd like for you to highlight the reason why you think that if the Supreme Court goes against this ruling, it will become...
Yeah, because I'm saying that because of a precedent, if Supreme Court goes against that judgment becomes a bad precedent, which people, succeeding generations of Nigerians are going to be referring from now till the end of the world. And that's why we are saying, it's not just, I'm not against, President Tinubu or Obi or Atiku. What I'm really saying is that we have judicial norms which, people have subscribed to, their courts have subscribed to, and even the public know about it. Now, the courts are not going against this. One of them is the Constitution, going against the Constitution, Section 137, which says that, look, for instance, before anybody can be made a president, that person should not be a dishonest person, should not be a person that has
should not be a what?
A very dishonest person.
A dishonest person.
And it's not a person that has anything to do, has not been involved in any crime and all that, Now, the verdict did not,
they didn't say it was a civil
dance
case.
Around it. You
case.
cannot have you cannot have a forfeiture without a crime, okay? There are so many things. So I don't know the way they went about it.
But are you sure that you cannot have a forfeiture without a crime?
I do not think so. I do not think so.
No, I mean, you are quoting a ruling. Is that like a precedent?
No, I'm not. I mean, what I'm saying is that if this ruling remains unturned, it's going to be a bad precedent. That's actually the point I'm trying to make. That any candidate who is contesting for running for president in 2027, or subsequent presidential elections, always cite it and say, look, I don't have a certificate, I don't have anything, I'm not qualified, but there is a Supreme Court decision on it. You are accusing me of so and so, there's a Supreme Court decision on it. I think I'm not, with due respect, I'm not trying to put word in anybody's mouth, I'm not trying to run down anybody. I think the Supreme Court is going to do a general review, even if not necessarily mean upturning the whole thing. Because if it is left the way it is, it's a dangerous precedent.
Okay, if I can...
On both sides, on the side of whether you are, I'm talking about justice, I'm talking about people referring to that decision and saying, look, I don't have qualification, there's a decision. I don't have so and so, there's a decision. I'm not supposed to score 25% of votes in Abuja. There's a decision. So that's why I think that, going by sense of justice, the Supreme Court should do something.
Okay, I'm very happy that you've mentioned this Supreme Court, because in looking at your piece, you highlighted the fact that you argued that the 6-9 verdict disregarded substantial evidence presented by the petitioners and instead relied on technicalities. But the court noted that these procedural blunders by the petitioners' legal teams, including failure to file witness statements on oath as required, paragraphs of petitions were deemed vague, they were imprecise and generic. And the court also spoke about the lack of credible evidence presented by the petitioners. So on this side, we're looking at the petitioner's case almost looking like it was watery to begin with. That is where, so let me just land on my point. And that is the same case, because they're not allowed to add any new evidence. They're taking that same case to the Supreme Court. So are we looking at a situation where the petitioner's case was just watery to begin with, and that was what the judges had to work with, the evidence that they were presented with, and of course following the technicalities that revolved around this particular case? Yes,
I think the petitioner's case was not very, was not watertight in the sense that it was not all perfect, and their lawyers did not, perform absolutely well during the hearing and all that. But the fact that, we are talking about justice here. For instance, one of the reasons why the expert witness, his evidence was jettisoned was because the court said that the witness statement of oath was not filed alongside with the petition while the suit was being filed, And so because of it, the court expunged his evidence because they said there was an irregularity, was not filed before. This is something that we look at. Not just that, also all the witnesses, their witnesses were, one of them, the evidence was expunged because they said he has a link with Labour Party and all that. And the other witnesses, just like that, were just decapitated, as I said in my listing. Now, there's a principle in law that you don't visit a scene, a scene committed by a counsel on a party, okay? But I'm saying that the court should have also looked at it the other way around and said, look, this scene was committed by lawyers to the Labour Party and all that, because they did not file the statement on oath alongside the petition. And now, the petition, the evidence is here. And don't forget that this expert witness was subpoenaed by the court. It was, to subpoena a witness is that it's like a command. The court commanded that witness to appear before it and give evidence. Now, when the Labour Party was filing the suit, they didn't know that the court has already okayed that command for the witness to come to court. So they filed without the statement witness of oath. And when the court was given, the court said, look, you should have filed alongside. In my humble view, I'm saying that the court will have looked at it the other way around, because this is a mistake of counsel, but it's also before the court, Other courts will have said in the past, okay, this is before us, it's a mere irregularity. We have to look at it, because when matters have come before the court, if you have a statement of defense that was filed out of time, once it's before the court cannot overlook it, because non-filing within time or out of time are mere irregularities. The court, in trying to do some substantive justice, we still look at that evidence because it's already before the court. So I think that the court will have also looked at it from the other way, agreed the lawyers to Labour Party and they made a mistake in not filing alongside. But at the same time, the court trying to do justice will have. Anyway, even without that, there are other parts of the judgment that people are critical. For instance, the European Union verdict on the election itself was also thrown away. So the international community, they are beginning to wonder, we sent our members to observe the election, and the court just jettisoned that report on the election, So I think this is an area that, the Supreme Court, I hope they will go back and look at it and all that, and see where justice has been there.
All right. I just want to ask you, you know that no president in Nigeria has ever emerged through the court. Why do you think that this
it's going to be
will be different?
In fact, you have said something that's very important because, it's not a normal thing for the courts to be putting governors, senators, members. It's not a normal thing. I mean, this is election that is done. It's the mandate of the people. The mandate of the people. So if the court is not supposed to be, kind of thwarting with the mandate of the people. Now you have, after elections, you have everybody now goes to court, and then the court will now start making pronouncements, putting governors, putting members of House of Reps and senators in power, and even the president. It has not happened in Nigeria, but that's why people are saying that it's going to be difficult. We know it's difficult, but like Odeli keep on saying that you can't say because something has not been done before, you cannot do it. If you think that, that's what we're talking about, justice must be done even if the heavens fall, okay? So it's not that because it has not been done before, now it can be done. It's about sense of justice. Like I'm saying, that justice to the society as well. That's why I'm saying that whether the Supreme Court, in their wisdom, affirms the verdict of the tribunal.
What will you consider justified in
what
this,
I would consider
justified?
Yes, what I consider justified is looking at the whole thing. It's not, people are not saying that. I'm not saying that P2B won the election. I won't say that because some people are saying that, look, people are saying that P2B. No, we are not saying that. What we are saying is that.
But you think he didn't win?
No.
Are you therefore saying
I'm not saying that. What I'm saying that there's a travesty done in the verdict. Travesty done to society at large. Not to anyone. By the pronouncement of the. I've mentioned the Electoral Act. I've mentioned the Constitution. I've mentioned the pronouncement. If you have that, you can do a rerun. A rerun, even. Because I'm not. If
a rerun happens, you are a lawyer, sir.
Yes,
if a rerun happens, you don't think that the likelihood will be between the proclaimed winner and the person who came second?
It doesn't matter. Even if President Tinubu emerges, wonderful.
No, I'm saying that the runoff or especially will be between the winner Tinubu and Atiku Abubakar.
Wonderful. I am for that.
Would that be justified to you?
Oh, justified to me because what I'm saying is that because I am here, like when I started saying that it's for justice, I'm here for justice. It's perfectly justified by me. If I did that rerun, Tinubu emerges as the president, I will be the happiest person in the world. Why? Because justice has been seen to be done. Not just done, has been seen to be done. I'm not here to hold brief for Labour Party or P2B. My brief is for justice. I'm saying that, look, the way people perceive this justice, this verdict, there is something wrong. And as a lawyer, I'm saying, look, and also not just as a lawyer, but also members of society are saying, if you go out there and meet anybody and say, look, what do you think about the verdict? You say, justice was not done in the
Well, that's what you said in your piece as well.
Yes.
You said that the petition court were biased to the petitioner.
It's a part of what I'm saying.
Let me tell you, a lot of
I'm not saying by saying that. I am not saying that judgment should be given to B or judgment should be given to.
Let me just finish my question.
I'm simply saying that if the court did its proper work, with due respect, I'm not running down the court. The tribunal, the judges of that tribunal are made up of people of
what I was trying to say is that some people will disagree with you.
Yeah.
Some people, not everyone believes what you're saying at this point. Some people believe that justice was done. People like Nobel laureate Wole Soyinka, who has been trending recently for saying that Peter Obi lost the election.
No, it's not that.
that the leadership of the Labour Party knew it, and they are trying to force a lie on Nigerians. I'd like to hear
would you respect,
your comment on that.
Would you respect, that people have been criticizing Oshoyinka for that, because, well, it could not, it's not about whether Peter Obi won the election or not. That's not the issue.
You are saying you shouldn't have said that.
No, the issue, you wouldn't have said that at all, because you have said, look, as we knew those days, you have first of all criticized the gerrymandering that took place, the unwholesome disregard for using Beavers and IRF. No? You have first of all criticized that. But he didn't do that. That's why people are now criticizing him and saying, look, wait a minute, okay? He couldn't have said that because he was talking about justice. Is justice done or not? It's not about whether people will be one or not. That's not the issue. The issue is that, look, if verdict boils down to doing justice to everybody, like I said, justice to society as well, there's no problem at all.
But you can't force your idea of justice on Professor Wole Soyinka. He was clear about how he arrived at his figures. And he said that even before the election took place at all, Mr. Peter Obi and Atiku Abubakar had donated the election, to APC because they split PDP.
He wouldn't have said that.
Oh, he said it
clearly.
No,
he wouldn't have said that because what I'm saying that
he said so
Wole
clearly.
Soyinka, he's not a lawyer. With due respect, with due respect, Wole Soyinka is not a lawyer. Is wonderful, a genius, but in this aspect, he's wrong because it's not about Peter Obi and what we are talking about is look, we have justice, substantial justice.
No, but you haven't given a reason why you think that
why he could have said that is that why
he's
he's wrong is that the issue is not about whether Peter Obi has won. The issue is that look, that the verdict, the conduct of the election itself was faulty. Said that Beavers was not used, IRF was not used. On that alone, on that count alone, the INEC should have qualified that election because
was not used.
Beavers was used. Beavers was used in the national election, and the other election bill was not used in the presidential election to upload the result of the election. In fact, I voted, and of course, we knew what
the story is out there. We know that.
So now, failure to do that is substantial enough to annul that election. Okay? What Wole Soyinka should have done was to question the credibility of INEC, not annulling the election. That was not uploaded through Beavers and IRF. He didn't do that, and it's not about whether it's just saying that Peter Obi. It's not the issue. The issue is that look,
you can't force your position on him.
No.
That's not his position.
Okay, here I said that, but we are saying that we reasonable people in the society. Wole Soyinka is just one more person. Okay, it's nobody else, but it's not almighty, God or whatever.
I think the issue also is that
Wole Soyinka can go wrong, and it has gone wrong in this case.
Let's talk about that, Beavers, again, that Electoral Act that you put in your piece. Yeah. Section 60, subsection 5, is that correct, of the 2022 election?
Section 148.
Just, we have very little time. I'd like for you to just highlight that section quickly as to the reason why you think that the petition court erred
Section 60 that INEC has to make rules or regulations that, lead to the conduct of the election, okay? That INEC has a right to make rules that will guide the conduct of the election.
Right.
By virtue of Section 148, INEC now also empowered INEC to specifically make provision for the use of Beavers and IRF. Now, under paragraph 38 of INEC rule regulation now, it stipulates that in uploading, after the election, the presiding officer shall electronically, upload results via Beavers and then subsequently the IRF. The word is shall, Now, after the elections were conducted, National Assembly election was uploaded, House of Assembly election was uploaded, the results were uploaded via Beavers. Then the presidential election results were not uploaded. And that's why we started having the controversy. Remember what happened that after that election, people were complaining, there were all sorts of mounting complaints, and before we knew it, the INEC chairman went and announced President Tinubu as the winner of the election. What people are saying that, look, put everything right. You use the Beavers, you use the IRF, no. Can you explain to the public why failure to use that? He didn't do that. All what he had was to announce in the 4 a.m. in the morning to announce President election. Right. And subsequently he went and get a certificate of return. We are saying that there is something wrong here.
We really have to go. But before we do, just 5 seconds. I know you have made your point.
Yeah.
The CJN will constitute the justices of, that will determine, the case by Wednesday.
Yeah.
When their verdict comes out, will you find closure in whatever they choose?
Of course. I mean, if the Supreme Court finally says it, I will subscribe to it because I'm a lawyer. I'm supposed to subscribe to what the Supreme Court has said.
All right.
We cannot be against the Supreme Court because it's the last court of the land.
Right.
We have to go ahead. We cannot, sponsor, violence or whatever. We can't do that because the Supreme Court decides that we just have to move on because that is the Supreme Court of the land.
Absolutely.
Well,
thank you very much.
Thank you very much for
Yes.
your insight on the morning show this morning. Thank you so much indeed.
Yes.